Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Well, hello there and welcome back to The Ride again this week. This is Ask a Lawyer here on CP24. Once again, John Scholes right in front of you. Joining me momentarily, employment lawyer Lior Samfiru from employmentlawyer.ca. I always tell you right off the top how you contact Lior anytime, on your own time. Phone call's good, 1-855-821-5900. Ask at employmentlawyer.ca. We'll get you an email address. We'll give you more contact information throughout the show. And of course, the website Pocket Employment Lawyer is there for you as well, pocketemploymentlawyer.ca. Radio shows, Sundays, 1 p.m. Join us on our brother station here, News Talk 1010 if you're in the GTA. And always welcome to call into the radio station. Maybe your phone call will make it on this show, and we'll talk about it. If it's a good question we all can learn something from, which is the point of this 30-minute show anyway, to educate you on workplace rights and employment laws. Main topic in just a little bit. If you're an employer, what you shouldn't do, because the consequences can be heavy. We'll get to that a little later on the show. But Lior, my brother, we always start off with a week that was something you've got cooking on your end, other than lamb for the past weekend. I'm sure that was tasty, but what do you got going on, pal?
Yes, thank you for that. Great to be here. Great to be talking about employment law and to try to help as many people by getting the word out that you have rights. You have rights, and too many people don't know what they are. Well, guess what? The law is kind of meaningless if you don't know what the law is, if you don't know what your rights are, and if you don't know what you can do if you're facing a workplace problems. Well, on this show every single week, we tell you what the law does. We make the law meaningful to you. Because guess what? If you lost your job, you have rights. If you're being mistreated in the workplace, you have rights. If you haven't received your proper compensation, rights. Your job has changed, you name it. Whatever that situation is, chances are you have rights you probably don't even know about. Why is that? Well, because we have some really good and comprehensive employment laws across the country, certainly here in Ontario. So that's why I want everyone to have that power, the power of knowledge. Now, we talk about a lot of things as much as we can cram into a 30-minute show on this program. But beyond just these 30 minutes, reach out to me in the office. If you want to have a private chat about your matter, we can talk about it. We can solve that workplace issue. We'll give you that contact information. You'll see it on the screen throughout the show. So stay tuned for that. But now that we know what we want to do, let's do it. Case of the day. Let me tell you about a situation that came across my desk very recently. Now, our regular viewers know that it's difficult to establish just cause for termination, even if you've done something wrong. That does not mean you can be let go for cause. And a reminder there, just cause means that your employer lets you go, and because of something so bad that you did, you're deprived of your severance. Now, remember, it's not enough to have just done something wrong to be deprived of severance. And this matter that I dealt with this week was a perfect example of that. I spoke with a lady that had worked at a restaurant for some 4 years or so. Now, very recently, she missed the shift. She said that her ride canceled on her. And yeah, frankly, she should have worked harder to get to work. Maybe she should have taken public transportation. She should have figured it out. Well, instead, she just missed her shift. Her employer, understandably, was not happy about that. I wouldn't be either, and nor would you. But what this employer did, the next day they called her and they're saying, because you missed your shift, because you are not here when you're supposed to, we're firing you for cause. We're not going to pay you any severance. What you did was bad enough that we can let you go for cause. So she called me and her question was, well, was it bad enough? The answer is no. Listen, she should have been at work. She should have done better in terms of her efforts to get to work. But her missing one shift in that situation is not enough to deprive her of severance. She's not deserving of the death penalty of the employment relationship, which means if she has to be let go, if her employer wants her gone, they can do that. But they have to pay her full severance. For her, that's right around 6-7 months of pay. That's what they owe her, even though she did something wrong. So the reminder here, obvious for everyone, you may have done something wrong. No one's perfect. Maybe you made a mistake. Maybe you didn't do something you were supposed to. That in itself does not mean you can be let go without severance. If your employer does that, it's a wrongful dismissal. You're still owed your full compensation. So if you lose your job, certainly if your company is trying to avoid your full severance, you call me right away.
Really quickly, Lior, how should the employer have handled that?
So that employer, if they wanted to try to let her go without severance, they could have tried to discipline her, build the case. So give her a warning saying you're expected to be at work every time, no matter what. If she misses work again, give her a second warning. Maybe then you can do a final warning. And then you may be in a position to terminate her for cause if the behavior continues. But to take one isolated incident and say that's bad enough, that's not legal.
As I mentioned, Lior, off the top, our radio show News Talk 1010 here in the GTA, Sundays 1 p.m. for an entire hour. Love doing that show. Love getting your phone calls on the air as well. You always ask great questions. And we'll get to our first phone call from the radio show now. Let's listen up.
My father, he's worked for the same company for over 30 years. He is going to be 72 in the fall. Now, if I've got my labor law right, they don't have to keep you on after 70. They can let you go with no reason whatsoever. Is that correct?
You got your labor law wrong.
She's got it wrong, but she's not alone in that. There's so many people that believe that there's an age beyond which your employer doesn't have to keep you, whether it's 65, 70. All of that is wrong. There is no such thing as mandatory retirement. We got rid of that many years ago. So you can work until whatever age you want, whether it's 65, 75, any other age. But it's more than that. If your employer decides to let you go because of your age, that's age discrimination. That's a human rights violation. They can't do that. So no, her employer does not have a right to let her father go without compensation. They're not allowed to let him go at all because of his age. So it's a question of severance. We want to know now how much severance is he owed, 72 years of age after all those years. Let's find out what that amount is. For that, I'm going to go use the severance calculator. You can find out, of course, at pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. So we see there, he's 72 years of age in a sales role, been there a long time, 30 years. The company says, we just don't have to keep your job, so you're gone. Nonsense. They have to pay him 24 months severance, as you see there. That's how much he's owed. Potentially more than that, because he's being let go because of his age, which is a human rights violation. So same with you. If you lose your job because of your age or any time, call me, or you can go to pocketemploymentlawyer.ca.
All right, we'll take a very short break here, get back into the show. What employers shouldn't do. Really important topic this week, so stick around for that. That's on the way as we continue Ask a Lawyer here on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer on CP24. Thank you for sticking around through the break. I'll give you some contact information, which we always do when we come back, so you can reach out to Lior on your own time. The phone number, 1-855-821-5900. Email right there, ask@employmentlawyer.ca, or scan that QR code anytime you would like. Lior, I mentioned a really important topic, especially, well, it doesn't matter if you're an employer or an employee, but you should listen to this for the next few minutes. What employers shouldn't do. Number one, here's a big one. We're going to start off the top, is don't fire an employee for cause if you don't actually have cause, right?
Just don't do it. It's not simple to terminate for cause. You have to do work if you're an employer to terminate someone for cause. You can't just decide to do it. You have to put in the efforts. You have to discipline someone. You have to give them an opportunity to improve. You have to show that there's no other possibility but to let the person go. So because of that, because the law makes it clear that a termination for cause is the death penalty of the employment relationship, you don't get severance, you don't get EI, etc., it's reserved for the worst offender. So unless you have an employee that's the worst offender, you can't let them go for cause. And if you try to let them go for cause when there isn't cause, you're going to still have to pay them severance. You're going to probably have to pay a bunch of money for your lawyer to defend you in a wrongful dismissal suit. And you may have to pay additional damages if you're acting in bad faith, potentially punitive damages, aggravated damages, etc. So employers, unless your employee did something terrible, like they stole, they committed fraud, or unless you built a proper case through prior warnings and discipline, don't fire someone for cause. If you want them gone, pay them their full severance.
Okay, Lior, number two, employers do not do this. Do not fire an employee if they're not ready to return to work from a medical leave or if their doctor says they need to go on one, right?
Listen to the employee's doctor.
Yep.
That's the lesson. That's the message here. You cannot let someone go because they're sick. You cannot let someone go because they're going to be off work and with that doctor's note. You can't let someone go because they're trying to come back from a medical leave. A doctor is the only one that can determine the length of absence. The employer doesn't get a say in that, okay? The doctor is only one. If you get a doctor's note, that's all you need. And you cannot do anything to that employee. You can't fire them because they're on disability, by the way. That's a human rights violation. So what does an employer do? What should an employer do? Listen to that employee's doctor. If they need to be off work, let them have that time off work and then make all efforts to bring them back. If that employee needs accommodation, provide that accommodation. Whatever the doctor says, modified duties, modified hours. Don't send them to another doctor for a second opinion. Don't question the doctor or tell them you don't believe them. That's never a good thing. Listen to the doctor, work with the employee to allow them the time off and to bring them back when they're ready.
All right, employer, no. Number three, Lior, don't change an employee's pay, hours, duties, workplace unless you have to absolutely do it, right?
Yes. Unless it's an absolute necessity, even then you may not be able to. An employer does not have a right to make significant changes to terms of employment. That means hours, that means duties, that means pay for sure. If an employer makes those significant changes, that could be a constructive dismissal, also with work location. So if the employee doesn't accept that, doesn't agree to that, you're, as the employer, at the risk of facing a constructive dismissal claim. What that means is that employee may have the right to consider employment as being terminated and get full severance. That severance could be as much as 24 months' pay. An employee, if you're the employee, if your employer's implementing these changes, you don't want to just continue working. You don't want to just accept, because then you may be stuck in that situation. You may have also given your employer the right to do it again. If an employer wants to be able to make changes, what they need to do is to have an employment agreement in place that gives them the right and the power to do so.
What we are covering off this week, of course, is what employers should do. The fourth and final one for this week, Lior, is this: don't treat somebody as an independent contractor. They stumble on this all the time when they're actually an employee.
John, this happens all the time. Employers misclassifying employees as contractors. Why? Because it saves them money. Well, if we just call you a contractor, that's great. We don't have to pay any government EI and CPP. We don't have to withhold taxes. It's just so much easier. It's so much better. Well, guess what? It's not legal to misclassify someone. If you have someone that looks like an employee and acts like an employee, they are an employee, and it doesn't matter what you call them. Now, if you're working for a company, you have a regular job, you work for one company, etc., you are probably an employee. It does not matter what the company you work for says that you are. It doesn't matter what you've signed. It doesn't even matter how you pay your taxes. The law makes that determination. Why do we care if someone is a contractor or an employee? Because an employee has employment law rights. The right to get minimum wage, to get vacation pay, to get holiday pay, overtime. Also the right to get full severance. Okay, every week I speak with someone that lost their job, didn't get paid severance because the employer thought they're not really an employee. Don't let that happen to you. And employers, if you actually are hiring someone to work for you exclusively, they're an employee. Treat them and call them an employee.
And that is our topic for the week. I want to reach out to Lior anytime if you want details on any of those talking points. But our radio show, again, News Talk 1010, Sundays, 1 p.m. Come on in, join us. Water's warm. Make that phone call, get on air with us, and maybe your phone call will appear on this show like we're going to get to phone call number 2 right now. Listen up.
I just want to know what the obligations are of an employer when somebody does return from maternity leave. So what if they're saying that they're a small company, there's financial strife in the company, and we can't afford to have that position anymore, we've eliminated it. So I'm just not sure what the recourse would be if the employer actually says, you know, no, we can't afford to take you back. Like, can they just say, you know, we're going to give you a severance, and what would the obligation of them be at that point?
So generally the rule is you cannot let someone go when they're on maternity leave or parental leave when they come back. You have to bring them back to work. Now, if you've eliminated the position, but I don't mean you've given the responsibilities to someone else. You've decided you're no longer going to be in this particular business, so everyone that was working in that particular business is gone. Yes, if it's completely unrelated, then you can let someone go with severance. But what you can't do is say, well, we've just taken the responsibility, we've given them to Bob and Joanne, so we don't have a job for you. No, that would be a breach of the Employment Standards Act. That can even be a human rights violation. That's illegal. It is difficult for an employer to come up with a legitimate way to let an employee go when they're coming back from parental leave. And certainly if you're an employee and your employer does anything to you other than bring you back to the same job with the same pay, call me right away. Chances are that that's illegal.
All right, good stuff, Leo. We got phone call number 3 coming up on the other side of the break, so stick around for that. And more content, maybe some emails to follow right here on Ask a Lawyer on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back to Ask a Lawyer. I always want you to reach out to Lior anytime you want a conversation on your own. Phone call is just fine, 1-855-821-5900. Email is ask@employmentlawyer.ca. And of course, the radio show Sundays, 1 p.m. News Talk 1010. Join us there. Let's get to phone call number 3, Lior.
If you have been working for a company for more than 20 years and the company is selling out and this person has been told that she will not receive her package because they are selling to a different company, is that true that they can actually force her to go with the new company, therefore not giving her a package?
So what happens on the sale of a business is if you decide to continue working with the company that's buying the business, you're not getting severance, you're not owed severance because you still have a job. On the other hand, if you choose not to continue working with the new company, and it's your choice, you get severance. Now, if you don't have a good reason as to why you're not going to be working with that company, you don't get your full severance, you get a small amount of severance. On the other hand, if you have a good reason why you're not going to be working for that company, maybe the job is different, the pay is different, the location is different. So you have a good reason. In that case, you are going to be owed your full severance up to 24 months pay. So let's go back to our severance calculator tool at pocketemploymentlawyer.ca. Let's plug this person's information in and see how much severance potentially he could be owed. So we know he's been there for 20 years. He's a manager at the age of 56. Yeah, we see that he can get up to the maximum, 18 to 24 months pay. You cannot be forced to continue working with the buyer of a business, and you may be owed severance if you decide not to continue working.
You can also join Lior anytime on his live stream during the week on Facebook, YouTube, and LinkedIn at stlawyers.ca is how you do that. Here's the question for this week, Lior. I started a fully remote, highly specialized job 6 months ago. Unexpectedly, the company now requires office attendance 3 days a week, which isn't possible for me. Can they change this despite my contract stating I work remotely?
No, the company cannot change that. What I mean by that is working at home is an important term of employment. As I said earlier, your employer cannot make significant changes to terms of employment. So no, that they don't have a right to tell you, we've decided instead of you working remotely, you now have to come into the office a few times a week. That's not possible. That said, if you refuse, company can still let you go because why? A company can let you go pretty much for any reason as long as they pay you full severance. But that's the key. If you refuse and they decide to let you go because of that, that could be a constructive dismissal. They would owe you your full severance, again, up to 2 years' pay. They can't use that as an excuse, as a reason to consider you to have resigned, and they cannot use that as a reason to avoid paying you severance.
We have time for one more email before we close out the show, Lior, but we'll do that after a short break, and we'll come back and do that right here on Ask a Lawyer on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer. I'll give you the contact information one more time here before we leave for the week. The phone number 1-855-821-5900. There's the email address, ask@employmentlawyer.ca. That is where we're going to go to wrap up the show. This one is an absolute beauty, Lior, so check it out. My brother's boss offered an ultimatum: return from temporary layoff at half pay or resign and look for a new job. Which option should I choose?
You know, John, I often get called with ultimatums or people telling me they're facing an ultimatum in the workplace. My boss says, I have to do this, I have to make a decision. And usually that ultimatum is nonsense because the law doesn't work that way. So here the employer says, we put you on a temporary layoff. We don't have a job for you. You can either resign or come back at half pay. Well, guess what? There's a third option, which is the only option here that makes sense, is he is owed severance. He doesn't have to accept half pay. That's not legal. He certainly doesn't need to resign. That's ridiculous. He can consider his employment as being terminated. An employer does not have a right to put you on a temporary layoff in most situations. So he can say, by putting me on this temporary layoff and now by not giving me my job back, you've terminated my employment. You have to pay me my severance. Not resigning. You've terminated me, and I'm certainly not taking half pay. You're owing me my full severance based on full pay. So that is the option here. Same with you at home. If you're put on a temporary layoff, you can choose to consider that to be a termination in most cases. Of course, before you do anything, call me.
And all that done in writing, of course, solidify your position, as we always do, right?
You know, the rule of thumb, the law that I kind of always abide by is if it's not in writing, it doesn't exist. So if you're having a communication with your employer, even if you speak with them verbally, follow up in writing. Make sure it's in writing. Email works great. If your employer tells you something and you say, gosh, I wish I had that in writing, no problem. Write it down or send an email to someone confirming what was discussed. You're doing that. By doing that, you're protecting and helping enforce your rights.
And that is it for this week. Reach out to Lior anytime, 1-855-821-5900, ask@employmentlawyer.ca, and of course, pocketemploymentlawyer.ca. We'll catch you next time right here on Ask a Lawyer on CP24.